Thanks for joining us today. We're going to be talking about what to do if an insurance company reaches out to you after an accident. I guess this is twofold. One is if it's your own insurance company versus the insurance company of the at-fault party. Okay, so let's start with your own insurance company. So if you were injured in an accident, you may be obligated, and probably are obligated, to cooperate with your own insurance company and communicate with them. There are several reasons why an insurance company might want to communicate with you or your own insurance company. One would be if you're potentially at fault and a claim is coming against you, and so they want to investigate and get your side of the story. But the other way is if you're making a claim to your own insurance company for benefits because of an injury or disability. They're very different. Those situations, although you're obligated to communicate with your insurance company, cooperate with them, provide information to them, you do have the right to have a lawyer. If your insurance company is reaching out to you to get information, particularly if it's because of an injury claim that you're advancing against your own insurance company, then we would highly recommend that you speak to a lawyer before meeting with your insurance company and providing too much information. Even though it's your own insurance company, at the end of the day, they may have an interest in limiting your recovery, limiting your claim. So again, speak to a lawyer so that your meetings with your insurance company, if necessary, you have the benefit of a lawyer representing you and giving you advice. What happens if it's the other insurance company? If the other insurance company is reaching out to you, and this is the insurance company for the at-fault party or the individual or company that caused your injury, then you want to be really careful about speaking to them or giving them information. We would suggest do not sign any documents for the at-fault party's insurance company unless and until you speak to a lawyer. Do not give any statements, particularly recorded statements. The insurance adjuster is trained, they're sophisticated, they do this regularly. They can take a statement that ultimately that can be used against you to either minimize your claim or defeat your claim. Sometimes insurance companies will try to quickly settle a claim so that they can get away with paying as little as possible. If they offer you money to settle your case, don't be in a hurry to accept this and sign off on settlement documents until you've obtained the advice of a lawyer. You may be giving up rights to future claims and rights to much more. In fact, we have examples where people have been offered settlements and then communicated with us, and one review of the file and the facts and circumstances of their injury and accident, it became really clear that the settlement was grossly inadequate for the nature of the injury. There was much more that they could have recovered. In many situations like that, if we do take on the case, it's because we're confident that we can ultimately recover much, much more for the injured party. So before you sign or accept the settlement check or deposit a settlement check, speak to a lawyer and find out if the settlement being offered is actually fair. In fact, if you're ever asked to provide a recorded statement, whether it's from an insurance company or really anyone else, in respect to your accident or injury, either a written signed statement or a recorded statement, that should be a red flag. You should consult with a lawyer if you haven't already. It's important to understand why they're asking the questions and what your answers mean ultimately in the broader context of your claim. The best way to fully understand that is to have a lawyer who is experienced in personal injury claims and can give you the right advice and also be there with you in the event that you are required to give a statement. Very often you're not required to give a statement. If it's the at-fault party or their insurance company requesting to meet with you and record a statement, in our practice, we would generally decline that. We would say no. Nothing really good comes out of giving a statement to the insurance company outside of the context of a lawsuit. So if that occurs and they're reaching out to you, be really careful about speaking to insurance people for the at-fault party. They may be trying to set you up. Most personal injury lawyers will offer a free consultation You can call us anytime, request a free consultation. We'll sit down with you. We'll listen to all the facts of your case and your injuries and give you advice and answer your questions so that you can make an informed decision. And there really is no obligation to hire us. There's no risk to you. You get your questions answered, and if you decide you don't want to hire us, anything you say to us remains completely confidential. We hope you found this topic informative, and as always, if you have any questions, feel free to reach out to us. Our contact information is listed in the show notes below.